I'm Gary Feldman.
I'm Tamsin Kaplan.
So we're David's Malm. We're two of the lawyers in the employment group. Welcome to our presentation on some new developments in employment law.
Well, I just got back from Rhode Island where I filled my prescription for medical marijuana. Not really. But the pharmacist gave it to me in a childproof baggie. And the directions on the baggie say, take medication, 2 hours later, eat everything in sight. But seriously, as you know, we have new legislation in Massachusetts, and very soon we're going to have dispensaries for medical marijuana. Typically, medical marijuana is used for pain, for situations where traditional medicine is not helpful, and sometimes for stress-related issues. Obviously, employers have concerns. Right now, many employers have either mandatory or random drug testing, including tests that would obviously pick up the use of marijuana. And some of you, depending on whether your companies use heavy equipment, whether people are driving motor vehicles in dangerous situations in their jobs, may be very strict about drug use among your employees. So medical marijuana is going to be an issue if somebody has a disability and they have to take medical marijuana. That's their prescribed treatment. Is that something that you have to accommodate? Do you have to allow them to use it? That's the question that is going to be facing employers. Okay, this is our first true-false, so get ready. Medical marijuana is coming to Massachusetts. Your employee comes in with a medical marijuana prescription and tells you he needs to smoke a joint every day at lunch. A whole joint. You are required to allow his use of medical marijuana as a reasonable accommodation under the ADA or state law. Is this true or false? What do you think? Okay, how many people think it's true? How many people think it's false? Oh, you guys are good. Did you know they were going to be this smart? Okay.
I think someone leaked them the slides.
So far, what we're seeing in other states is that there is not a requirement to accommodate the use of medical marijuana, even if it's use that is off premises. I mean, in the Massachusetts statute in particular, it says that an employer is not, it says, nothing in this law requires any accommodation of any on-site medical use of marijuana in any place of employment or of smoking medical marijuana in any public place. So it's explicit about on-site use of marijuana. However, it doesn't say anything about this other issue that I was just talking about, whether if somebody has, say, a positive drug test for marijuana, whether you can terminate them for that. And what we're seeing in other states is that this is a question that is a little bit, it's developing in the law. But in states where they have similar provisions that say you can't use it on site, for the most part, the courts are coming out in those states and saying that that means that you can terminate somebody if they test positive. So let's look at this one, having just given you a little clue. An employee with medical marijuana prescription is terminated for using medical marijuana at work or for testing positive for pot. The company will now be exposed to a huge award for terminating the employee in violation of the public policy of allowing medical marijuana. True? False. Okay. And we're saying likely false. And the reason we say likely false is because this law has not developed in Massachusetts yet. Obviously, we don't have any legal medical marijuana in Massachusetts yet. When we do, we again are expecting that because of that provision in the law that says you do not have to tolerate on-premises use during work time, we are expecting that, like other states, the courts are going to come out and say that you can terminate somebody for testing positive on a blood test.
The cases that have dealt with it so far, and there hasn't been a federal case in this jurisdiction, but the last time I looked, cases that had addressed it as a matter of federal ADA law. And since marijuana is still a Schedule I controlled substance under federal law, the cases all held, and there were 2 or 3 cases from the 8th Circuit and the 10th Circuit case out west that said as a matter of federal ADA law, there's no right, there's no reasonable accommodation that an employer is obligated to give, to provide for someone to smoke marijuana with or without a medical prescription. And so as a matter of federal law, there are no rights, and that's why it's likely false, because state law may be developing on a parallel track that may diverge as time moves forward, particularly in Colorado and in Washington, where, as you know, we're beyond medical marijuana, and marijuana is a legal substance, just like going to an going to a liquor store.
Well, what I recommend, and I think Gary may differ in his advice, so I'm interested to hear what you say. What I'm recommending for Massachusetts employers is that they keep in mind whether, in fact, there is any bona fide business reason to require a clean blood test. If somebody has a disability, they're getting legitimate treatment from a doctor, including use of medical marijuana, and it's not affecting their performance, it's not affecting safety for them or for any coworkers, then I would say think long and hard before you terminate that person for a positive drug test showing marijuana.
The bottom line is there's no justification or no legal permission for using marijuana on the job as opposed to other prescriptions. But other prescriptions, particularly for people that are in safety sensitive positions, there are many people who are maybe on painkillers or on other legal prescriptions where their prescription would impair their ability to operate heavy equipment or perform in a safety sensitive position, and the employer is entitled to limit or reassign, but limit that work for that situation. So even with medical marijuana, it's clear you do not have an obligation under Massachusetts law to allow the use of medical marijuana on the job site during the working day. So the question that becomes trickier is on a conditional offer of employment, pre-employment drug screen, someone tests positive for the presence of marijuana, and they provide to you a medical prescription under when the dispensaries finally do open in Massachusetts, how to handle that.
So stick with us. Yes, Jeff?
I had a question. If the federal law changes in any way, do you think that changes everything? If they decide, okay, it is medically, we allow medical marijuana?
Well, at this point, as Gary said, the law is developing on two tracks. And right now, under federal law, it's absolutely not required because it's not legal. Then there are state laws. There are some states now that are saying, well, it may be an accommodation under our disability laws. Some states then say, well, no, because it's trumped by federal law. Other states say, yes, under state law, this is a required accommodation. And so I think if federal law changes, then it's more likely that the states will easily go along with it and not allow you to terminate somebody for use of medical marijuana unless it affects their job, unless it's some kind of a legitimate job concern.
Yeah, it's not something that's necessarily dealing with, but I'm just curious, like, the federal law changes, states really aren't likely to say, no, it's still illegal in our state, even though the federal...
Probably not. One of the things that, but we talk about states and it's all very general. One of the things to note is that most of these legalization of marijuana laws have come from referendums. So they're coming not from the legislators, they're coming from the public, from these grassroots efforts. So the amount of commitment to public policy in state government, I think, is not yet clear. But it does appear that that's the way things are going. I think I agree with you that for the most part it's going to get more and more lenient over time. But the fact is, if there's a safety concern or if use of marijuana affects somebody's ability to do their job, then they're not a qualified, it's not a qualified handicap. They're not a qualified person for their job. They can't do the essential functions of their job with or without an accommodation, and you'd have to let them go or require that they not use it. Does that make sense? Yeah.
For schools, if this changes, does this no longer become a drug-free zone and they can smoke it on campus?
I doubt if that's ever going to happen. Two things. Number one, I think we're mostly talking about using it, off premises, not on premises. I don't think that's ever going to happen. And in Massachusetts law, it specifically specifies that this does not mean you have to permit on premises use for employers. The other thing is that for the way that medical marijuana is actually prescribed, it's not necessarily smoking. There are inhalers, there are pills, so it can be taken like other medicines.
I think the most difficult, fast forward a few months, because eventually the Department of Public Health in the Commonwealth will get its act together and start licensing, and we're soon going to see the actual opening of real medical marijuana dispensaries. So fast forward 6 months from now, I think the most difficult question that you'll be facing and that will be on the receiving end of calls about are pre-employment drug screening tests. So a conditional offer of employment, typically many companies, many of you may require as part of a background check a drug screen for all positions or only for certain positions. So right now, if you do that and that test comes back positive for marijuana, I believe that the employer would be entitled to treat that as a failing drug test and rescind the conditional offer. Fast forward 6 months, medical marijuana is here. You perform that same pre-employment conditional drug test, and you've got a candidate who tests positive but produces a valid prescription from a licensed physician. That person's got a valid prescription for marijuana. Then that raises a whole. That's the hard question. So what is the employer's role and responsibility then in either a safety-sensitive position or a non-safety-sensitive position? You've got reasonable accommodation issues. Is that person to be treated just like anyone else who's suffering from a medical condition? Or will you be free to reject that person on the grounds of a positive drug test? I think, I think it's going to, that dividing line is going to be on the nature of the position. In a safety-sensitive position, someone operating a truck driver on the road, someone operating heavy equipment, dangerous equipment, may lead to one set of answers as opposed to someone in a non-safety sensitive position.
But right now, you can have somebody come back with positive for Ritalin right now. So wouldn't the medical marijuana person have the ability to say, well, but you can reject so-and-so who I know takes Ritalin and produce their prescription because they have ADHD?
Mm-hmm.
Is there a fairness sort of?
Well, I think that
would be exactly the argument.
Yeah, that would be the argument, that there is, like I said, there are a whole range of prescription medications that people lawfully take that could show up on a drug screen, some of which may have a tendency to impair their functioning on the job in certain positions, some of which may not. I'm not familiar enough with Ritalin to know in what way that would affect someone's ability to perform a safety-sensitive position.
Well, it wouldn't, but,
So that's why it's a someone would treat.
You come back positive and somebody says, oh, you're positive, and you say, but I need this for.
But the next inquiry then is, does this affect the person's ability to do their job? Does it affect their safety or someone else's safety? And I think that's the analysis that we should be thinking about with medical marijuana as well. Because although right now at this moment you can just reject an applicant or terminate an employee for testing positive, I think down the road we're going to be dealing with this in a much more surgical way.